the single most laudable bankruptcy legislation ever to emerge from Congress was subchapter 5, which makes it economically feasible for smaller companies to reorganize successfully in chapter 11. There is a split among the lower courts on a significant issue that may make subchapter 5 unreachable for some companies. The question is this: is the future liability on a long-term lease a debt that must be counted toward the cap of $7.5 million, which is the most that a company or an individual can have to reorganize in subchapter 5? On the one hand, we have a bankruptcy court in Virginia which held that yes, the future liability of a lease, all of the future liability, is considered and counted toward the $7.5 million cap. On the other hand, we have a bankruptcy judge in New York City who held to the contrary and said no, that future rent due on a long-term lease is not counted. Well, I tend to approach the question as a matter of policy, and I will admit right up front that policy is not how courts decide questions these days, but yet perhaps this is an instance in which some considerations may persuade courts on how to interpret the statute. Let's take the case of a company with a long-term lease, and let's also assume that the rent on the lease is favorable. Now, from a realistic point of view, that long-term liability really isn't a liability. In fact, the lease is an asset. Indeed, it may be the most valuable asset that the company has. And furthermore, if the rent on the lease is reasonable, that company in subchapter 5 could assume and assign the lease and actually make money on it. Furthermore, generally accepted accounting principles, in essence, do not show future liability on a lease to be a debt. Yes, as a matter of fact, there is a liability under GAAP principles for future rent on a lease, but on the other hand, there is an offsetting asset, which, as I indicated already, makes sense because a lease really is an asset, and when you put those two together, they balance out, and the result is, on a balance sheet analysis, there is no liability for a long-term lease. Well, my guess is this issue is going to kick around for quite some time, and it's my personal hope, and I might say belief, that eventually courts are going to decide that at least in a circumstance where a debtor is going to retain a lease, that liability is not a debt to be counted toward the $7.5 million cap. I am Bill Rochelle, the editor-at-large for American Bankruptcy Institute. The good Lord willing, I shall be back same time next week with something interesting from the world of bankruptcy. Until then, be well, stay safe, and a good day.